Okay. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, you've been asked to come to court for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with and what your options are concerning your case. The case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they're convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. Now, if a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishments because, as I mentioned to you earlier, your offense is classified as a misdemeanor. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that start in the JP court or the municipal court, which is a city court. They come to this court, County Court at Law, when the person either pleads guilty or no contest or is found guilty, and then they appeal their case. When they appeal their case, they get a whole new trial in this court. So they start back at square one. And just an example of a Class C misdemeanor would be not wearing your seatbelt, or speeding, or running a red light. Those are Class C misdemeanors. Now, they come to this court when the person appealed their case. Now, the punishment range for a Class C misdemeanor is fine only. You cannot be given jail time. It's fine only. And the fine cannot be above or cannot exceed $500. Now, if the person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capious pro fine. I'll explain that to you. A capious pro fine is a warrant for the person's arrest for them to either pay the fine, or if they cannot pay the fine, they would have to sit the fine out in jail. And if they sit the fine out in jail, for every 1 day that they sit in jail, it will be credited $100 that will go toward the payment of their fine and court costs. Now, the next highest misdemeanor You have the class C misdemeanor. Now the next highest misdemeanor is a class B misdemeanor. But the class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine or jail time, or fine and jail time. Now, the highest misdemeanor is a class A misdemeanor. Now, the range of punishment for a class A misdemeanor is minimum 0 days to maximum 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and jail times. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. And sometimes it's referred to as deferred adjudication. It's unadjudicated probation. And the other type is called adjudicated probation. You got unadjudicated probation and adjudicated probation. Now, with the unadjudicated probation, it does not result in conviction on your record. And if you successfully complete the probation, you will not have a conviction on your record. And you may qualify, well, the case will be dismissed if you complete it, and you may qualify for what is called a non-disclosure. A non-disclosure basically means that your record will be sealed to the general public. So the general public cannot have access to your record if you receive deferred adjudication and you get a non-disclosure. Now, the operative word that I use was general public. The general public cannot have access, but there are certain governmental agencies that can, and those agencies are listed in the Texas Code of Criminal Procedure. Now, the police, which is a governmental agency, they can't have access. But for example, if you are applying for a job, say with Exxon Mobil, and you have a non-disclosure, they do a criminal background check. This would not come up because their record is sealed to them. And because they're part of the general public. All right. Now, the next type of probation, we had unadjudicated probation. The next type of probation is called adjudicated probation. With the adjudicated probation, it does result in a conviction on your record. However, there is something that is called judicial clemency. What that means is the judge can set your conviction aside, and you will no longer have a conviction on your record. Now, in order to qualify, 3 things has to happen. 1, you have to successfully complete the probation. 2, there cannot be any more time left on your probation. And 3, you have to be discharged or let off the probation by the probation office. And if those 3 things happen, then the court has the discretion to set your conviction aside, and you will no longer have this conviction on your record. Now, however, if you get the language is a subsequent conviction, that is, if you get another conviction later on, and if you try to apply for, say, a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. All right. Now, everyone here should have a clipboard. Is there anyone here that does not have a clipboard? That is here for a case. All right. And the reason why I asked is because I'm going to go over that paperwork with you. Now, that first document behind the little short document is titled Judge's Explanation of Rights to Defendants Without Attorney. That document looks like this. Okay? It looks like this. And in that document, it states that as a defendant in a criminal case, you have 3 options. 3 options regarding your right to have an attorney. And they list the options. Number 1, you may hire an attorney. Number 2, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Those are your 3 options. Now, the first 1 sentence paragraph below number 3 states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date from today's date to give you time to hire your attorney. The next one sentence paragraph states that if you want an attorney but you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, this is only for people who will be applying for a court-appointed attorney. Now, the financial questionnaire is a 3-page document that is also on the clipboard. And this is only for people who will be applying for a court-appointed attorney. So if you're not applying for a court-appointed attorney, you don't have to worry about going to get rid of it. But if you're applying for a court-appointed attorney, you would have to fill out the first page of this document that is titled Affidavit of Indigence or Jefferson County Affidavit of Indigence. You fill out the first page. And then you will go to the second page. And on the second page of that document, you'll fill out the top portion that is titled Defendant's Oath. Okay? And then you'll fill out the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. Okay. Now, going back to this first document, judge's explanation. The next one sentence paragraph, this is for individuals who will be representing themselves. Okay. You have a right to represent yourself. And if you represent yourself, you will be your own lawyer. And just like a lawyer, if you had a lawyer representing you, your lawyer would be able to talk to the district attorney or the prosecutors. We have assistant district attorneys in court. We have 2. And if you're representing yourself, you'll be able to talk to the attorneys as well. Okay, because you are your own attorney. Okay, and you can talk to them about your case to see if you can work out a settlement on your case. And if you're able to work out a settlement on your case, we call that a plea bargain agreement. All right. Now, this paragraph, this third paragraph, one sentence paragraph states that you may not speak to the prosecutor unless you first sign a waiver of your right to be represented by an attorney. Now, this is only for individuals who will be representing themselves. The waiver that you would have to sign is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. This is only for people who will be applying as their own attorney. If you are hiring your attorney, you don't have to worry about this document. If you're applying for a court-appointed attorney, you don't have to worry about this document. You only fill this document out if you are representing yourself. All right. Now, this one sentence, this paragraph in block form is for people who will be representing themselves. It states that, be aware that the dangers and disadvantages of self-representation, waiving your right to an attorney, and representing yourself may result in the worst outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you are representing yourself, you may change your mind at any time. For example, this is what this sentence says, this one sentence, that says that, okay, let's say you're representing yourself. And let's say you would like to take probation, all right? And you talk to the prosecutors, and the prosecutors say, well, I'm not going to offer probation, I'm going to offer you a fine. And you say, well, I don't want a fine. Then you could say, well, Judge, I changed my mind. I want to represent myself. I want to apply for a court-appointed attorney. So, or you could say, Judge, I want to hire my own attorney. Okay? Those are, or you might say, well, Judge, I don't like their offer, Judge, I want you to set my punishment. You have those options. All right. Now, at the bottom of this document, there in bold letters, it says defendant's choice. Marking issues next to only one choice. Now, everybody in here for arraignment, you will make one, you're going to make a choice of there are 5 lines here. Okay, to the left, there's 5 lines at the bottom to the left. Okay? If you are hiring your own attorney, then you'll place your initials on the first line to the left at the bottom. If you're hiring your own attorney, you place your initials here on the first line, then you assign where it says defendant, you will date today's date, say no denial, and this is the only document you would have to sign. And then you'll stop. Okay? If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left. That's only for people who hired their own attorney. Place your initials on the second line and the name of the attorney on the line to the right. Then you'll sign this date, you'll sign where it says defendant, put the day's date, and then you'll stop. This is the only form that you would have to sign. All right. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left, sign, where it says defendant, dated today's date, and then you would have to fill out this document that is titled affidavit of interest. You fill out the front page, go to the second page, fill out the top portion that's titled defendant's oath, and then the middle portion that's titled unsworn declaration by defendant, and then you'll stop. Now, if you have already been appointed a court-appointed attorney, and I don't think anybody has, but if you have been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left at the bottom. Sign this form, dated today's date, and put the name of the attorney on the line to the right, right here, to the line to the right, and then you'll stop. Now, if you would like to represent yourself, that is, you'll waive your right to an attorney, you'll be your own attorney, then you'll place your initials on the last line, the fifth line, to the left, sign where it says defendant, dated today's date, and then you go to this form that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. That's the title. You would have to fill out, read this form, sign it, date it, and then you'll stop. Okay, before I go any further, do we have any questions? Any questions? And at the end, if you need help filling out the forms, we have our court personnel, including myself, who will be happy and able to assist you with filling out the forms. Okay? All right. Now, the next thing I need to talk to you about right now is the rights that you have. One right that you have, well, first of all, you can enter one of 3 types of pleas. You can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or if you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of no contest, which means you're telling the court that you're not fighting or you are not contesting the charges. Okay? Now, if you enter a plea of, say, guilty, a plea of not guilty, you basically tell the court, I want a trial. Now, you have a right to have a jury trial. When Mr. Stewart is sitting in that area, there are 12 chairs. We call that the jury box. There's 12 chairs, but in county court, you have a 6-person jury. So 6 people from Jefferson County will be selected to serve as jurors in your case, and they will listen to the evidence that's presented by the state and the defense. They will listen to the arguments of the state and the defense. They will go back into the jury room to deliberate, and they can either find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. You can still have a trial, but it's not called a jury trial. It's called the bench trial. And the reason why it's called a bench trial because it's a trial by judge. Judge sits on the bench. They call it a bench trial. Now, the judge will be the judge and the jury in the case. The judge will listen to the evidence that's presented by the state and by the defense, to the arguments of the state and the defense, and then the judge will apply the facts to the law and decide to find you either not guilty or guilty. Now, you also have a right to say, well, I don't want to have a trial by jury or by judge. I would like to see if we can work out something on my case. I want to interview with no contest. I want to see if I can work out something on my case. And if that's the case, then you can see if you can enter into what is called a plea bargain agreement. Now, if you are able to reach an agreement, we call that an agreed plea bargain. So let's say you would like to get probation, some type of probation. Talk to the prosecutor, prosecutor's offer you probation. You say, fine, I'll take it. Y'all have an agreement. It goes before the judge. The judge can do one of two things. The judge can accept your agreement or reject your agreement. If the judge rejects your agreement, guess what? You can say, well, judge, since you're not following the agreement that I made with the state, I take my plea back. In essence, I'm not pleading guilty. I'm not pleading no contest. You have a right to do that. The law says you can withdraw your plea if the court does not follow the agreement that you worked out with the state. Now, if the judge does follow the agreement and it comes before the judge, and let's say you say within 30 days, you say, oh what? I think I was wrongfully convicted. I want to appeal my case. And if that's the case, you have to get permission from the judge that follows the plea bargain agreement. And if the judge gives you permission, your case is going to leave this court. It's going to go to the Ninth Court of Appeal, and they're located right above us on the 3rd floor. There are 4 judges up there. They'll review your case to see if you were wrongfully convicted. And they can do one of 2 things. They could grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can say, you know what? I'm going to send this case back down to the county court at law number 2 and order them to give you a whole new trial. Now, if they deny your appeal, it's still not over. Because even though they deny your appeal, you can appeal it to a higher court than the Ninth Court of Appeal. You can appeal your case to the highest criminal court in the state of Texas. And it is called the Texas Court of Criminal Appeals, located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. I will explain that to you. Pro se means self. In essence, I don't have a lawyer representing myself. And I'm petitioning, which means I'm asking the Texas Court of Criminal Appeals to review my case to see if the Ninth Court of Appeals should have granted my appeal or whether county court at law committed an error by wrongfully convicting me. Okay? They can do one of 2 things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty and case is over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your petition, then at that point, the conviction will stand. Okay. Now, if you and the state have not been able to reach an agreement, but you still would like to enter a plea of guilty or no contest, you have the option to have the judge to go before the judge and for the judge to set punishment. That's called an unagreed plea. Why is it unagreed? It's unagreed because you have been unable to reach an agreement with the state. And so you still have the option to go before the judge on an unagreed plea. Okay? Now, the next thing we need to talk about is your right to have witnesses to come to court. If you decide to go to trial, well, you have a right to have witnesses to come to court. They sit in that chair that has the microphone in front of them. And what witnesses do, they can either testify for you or against you. Your attorney has a right to ask them questions, or if you're representing yourself, you can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. What that means is that you will not be calling witnesses to testify. It does not mean that the state will not be calling witnesses to testify, because they will be calling witnesses to testify. And you also have a constitutional right. It's called the Fifth Amendment right against self-incrimination. What that means, you have a right to remain silent. The state, the government, the district attorney's office cannot call you to a witness stand if you exercise or invoke your Fifth Amendment right against self-incrimination. Okay? Now, I know a lot of times we watch these law shows on television, and we see the television lawyer go up to the witness stand to ask a question, and the person on the witness stand says, "I take the fifth." What they mean by that? I'm not saying nothing. In essence, I'm exercising my Fifth Amendment. The fifth is the Fifth Amendment right against self-incrimination. I'm exercising my Fifth Amendment right not to say nothing. You can't make me say nothing. I take the fifth. Okay. Now, it makes sense. Why does it make sense? It makes sense because the state has the burden to prove that you committed the crime. They have to prove that you're guilty. You don't have to prove yourself guilty. Right? So you have a right to take the fifth. Now, the other thing, you can waive or give up your Fifth Amendment right. Now, if you waive or give up your Fifth Amendment right against self-incrimination, in essence, you're saying, I'm taking a witness and I'm testifying. They can't force you to do it. You have to voluntarily waive your Fifth Amendment right against self-incrimination. All right. Now, the other right that you have a right to have discovery. I'll explain to you what that is. They use the word discovery. And the reason why discovery means you have a right to see what's in the state's file. What the file that they have against you, you have a right to see the evidence. You have a right to see your statements, witness statements, police reports, lab reports, audio recordings. You have a right to listen to audio recordings, see any video recordings, photos, documents, objects, whatever they have. You have a right to have access to that. That's called discovery. I guess they call it discovery because you have a right to discover what's in the state's file. Okay? So you can waive or give up your right to that discovery. I mean, that's you say, well, I don't want to see what's in the file. You can waive or give if that's your desire. You have a right to do that. All right. Now, everyone that's here today for a case, you have had charges filed against you. You've been arrested, placed in the county jail. You bound out of the county jail. You're out of jail either on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail. Or you're out of jail on what we call a PR bond, or you're out of jail on what is called a personal recognizance bond, which means you didn't have to pay any money to get out of jail. You were just released under your own personal recognizance with a promise to appear today. Now, I've said that to say this. Every day that you spent in jail can be used as credit toward your punishment. So, for example, now the operative word is every day. Now, I'll give you an example. Let's say you were booked into jail at 11:59 p.m. last night. And let's say you booked out of jail 2 minutes later at 12:01 a.m. Guess what? You was in jail 2 minutes, but that's 2 days. It's 2 days because it's 2 different days. One day was Monday and the other day Tuesday. So you get credit for 2 days. So if you was in jail 5 days, that's 5 days credit. If the state is offering you punishment of 5 days in the state, in the county jail, that means you don't have to serve any more time in the Jefferson County jail because the time that you spent in jail you have already served. So you'll be given credit for time served. Now, if you spent 5 days in jail, they offer you 7 days in jail. That only means you have to spend 2 days in jail. And how do we get the 2? We subtract 5 from the 7. That leaves 2. Now, every day that you spent in jail, you also get credited $100 per day that can go toward your fine and court costs. So if you spent 5 days in jail, that's $500 that can be used towards your fine and court costs. So if the state is offering you a fine and court costs of $500, that means you don't have to pay. Because the 5 days that you spent in jail is $500, and $500 you be given credit for that time. It'll be taxed and retired, which means you won't have to pay it. Now, if the state is offering fine and court costs of $700, you spend 5 days in jail, which is $500. That means you only have to pay $200 because we subtract 500 from the 700. That is 2. You'll be required to pay it on the day that you take care of the case. If you cannot pay it, guess what? We can put you on a payment plan where you can pay it off in small monthly installments each month until it's paid off. If you cannot pay it off on a payment plan, no problem. Because we can convert your fine and court costs to community service. And for every 1 hour of community service that you perform, $12.50 will be credited toward payment of your fine and court costs. So if you work 8 hours of community service one day, guess what? That's $100. So in our scenario, you owe $200. You work 2 8-hour days, that's $200 you paid off your fine and court costs. All right? Now, Jefferson County has a program. Jefferson County District Attorney's Office has a program for people who haven't been in trouble with the law before. When I say been in trouble, they convicted and had cases where they have prior convictions. If it's your first time, if it's your first time with 1 or more cases, the District Attorney's Office has a program that is called pretrial diversion. With pretrial diversion, you get into the program. Once you complete the program, they will dismiss the case. And you can get it wiped off your record like it never happened. It's called expulsion. Right? Now, it's pretrial diversion. Only thing you have to do to get into pretrial, it has to be your first time getting in trouble with the law with 1 or more cases. It can't be an offense of unlawful carrying a weapon or resisting arrest, and you have to have an attorney to assist you to get into the program. The attorney doesn't have to be a hire. It could be a court-appointed attorney, right, to get into the program. And so, as I mentioned to you, you get into the program, complete the program, they dismiss the case, and you can get it wiped off, you get it expunged, erased, deleted, or wiped off from your record. That's what's called expunction. And so if somebody go and look at your record, guess what? They're gonna just see a clean slate. It's gone. All right. Now, the district attorney's office has another program that is called Veterans Court. If you're a veteran of any one of the branches of the United States military, they have a program that is called Veterans Court. And with the Veterans Court program, they will, only thing you have to do to get in the program is be a veteran. That does not, you gotta go through this story. Only thing you have to be a veteran of any one of the branches of the United States military to get into the program. Okay, with that program, you get into the program, complete the program, dismiss the case, get it wiped off, you're ready, okay? Now, the other thing is, this court, County Court at Law Number 2, has a program that is called the CSI program. CSI is an acronym, CSI, that stands for Community Safety Initiative. It is a program that God led me to start within the first 100 days of taking office. And that was in March of 2017 when we started the program. That program is designed to address the issue of what we call recidivism. I'll explain it to you. Recidivism means when people keep committing crimes over and over. Okay? They call it recidivism. The way we stop it is through our Community Safety Initiative. And with the Community Safety Initiative, we have partnerships with various agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health center that's located in the Southeast Texas region. And they have the expertise to address mental health issues. They have doctors, counselors, and other mental health officers that's there to address mental health needs. Now, you do not have to be incompetent or insane to participate in the program. You can just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address your mental health needs. And what they will do, we have some folks with Spindletop here today. They're gonna come and talk to you in a few minutes. But what they will do, they can do a private interview, either in our jury room at their facilities, by phone or by text, whichever is convenient for you. Then they can develop, they can do an assessment. An assessment is to determine what your mental health issue is. And then once they do an assessment, then they can develop a treatment plan to treat the mental issue that you may have. If you have problems with drugs or alcohol, well, Spindletop has a program. It's an acronym. It's ATAR. It's called ATAR, and it stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, which is an acronym that stands for Outreach, Screening, and Recovery. All of those programs are drug and alcohol recovery programs. And what they will do a screening, an assessment, and then they can develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed or if you're looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called OZAR, that's called CICE. CICE is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, then they will help you to get a job in the area that you are trained in. If you have not graduated from high school, or if you do not have a GED, which is a graduate equivalency diploma, Spindletop and CICE have GED programs. And they will help you to get your GED. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time. We take our time. That means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And guess what? If we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community. Why? Because what comes out of the home goes into the community. So if you are interested in any one of these programs, just let us know and we can get you started on the road to living your best life. All right. So at this time, we also have a partnership with Family Services. We have Mr. Johnny Stewart from Family Services. He's going to come and talk to you a little bit more about the program that they have. And it's for people who have cases involving family violence. And with that program, you get into the program, your case can be dismissed and you can get an expungement from the record. So at this time, we have Mr. Johnny Stewart, who's going to come and tell us a little bit more about that program. Mr. Stewart?
Thank you, Judge.
Okay.
Good morning. My name is Johnny Stewart, and I'm the fifth director, which is called Battery Intervention and Prevention Program. Used to be called the Domestic Violence Program. This is one of the programs that goes to get your case dismissed once you successfully complete it. It's 18 weeks. We also have the young minors from the Women's and Children's Shelter. We also have a program. It's 18 weeks. We have a Zoom program that's for these guys who are working. And that's on Mondays and Tuesdays. Then we have an in-person class on Wednesdays. Once you complete that, we will provide a certificate for you that you can provide to the ADAs, and you will have completed the program. What we do, we provide you tools and information to help you change those behaviors. Because we want to try to keep you from being in a situation where you have to be careful. So if you can take advantage of that program, do so. Very good program. And I appreciate your attention. Thank you very much.
Okay.
Thank you, Judge.
All right. Thank you, Mr. Stewart.
Okay.
At this time, we have some folks from Spindletop. We have Tanya and our mental health deputy Bill, and they're going to come and tell you a little bit more about the program that Spindletop has to offer.
Thank you.
You want
Good morning. I'm Josh Bill with the Sheriff's Office. I'm a mental health deputy. I'm assigned to Spindletop. This is my partner Tanya. She's with Spindletop. We work together as a team. Some of the paperwork, the little small habit sheets, the paperwork. It's not mandatory. You don't have to fill it out. It's just if you want to contact, it's a way of getting in touch with us, for us getting in touch with y'all. Then I'll let you explain more.
As Deputy Bill said, we're from the top. We help with services as far as mental health. We help with substance abuse services as well as military service. Remind that back to the work job. Deputy Bill and myself do meet one-on-one with clients. If you are already established in services and you need to update information, we can also update information with our substance abuse program. Sometimes the judge will also use it for you guys if you need to work with substance abuse. Depending on what exactly you are needing, we can assist you. With the prescription, with the assessment, if it needs to be in contact with employers, anything pretty much possible, we can help you. with that little sheet. If you would like to speak to us one-on-one today, or if you would rather text message or a phone call, you are more than welcome to do it. With this information, it is, I won't say inadmissible, but it will not be held against you if you guys speak with us. Thank you.
All right, thank you, Deputy DeVille and Tanya. Okay, ladies and gentlemen, what we're going to do, we get ready to go into recess. You'll have an opportunity to finish filling out the forms. Once you finish filling out the forms, we're going to pick up those forms from you. We will put you in, one of three categories. One category is you want to hire your own attorney. And if that's the case, your case will be reset today. And you'll be given another court date. The second category is you would like to apply for a court-appointed attorney, and if you qualify for a court-appointed attorney, your attorney will be appointed today before you leave. Now, the next category is you would like to, represent yourself. If you would like to represent yourself, then you'll have an opportunity to talk to the prosecutors, see if y'all can work out a plea bargain agreement. And if you're able to work out a plea bargain agreement, either with the state or if you do an unagreed plea where the judge sets the punishment, then your case will be taken care of today. All right, so before we go into recess, I need to inform you that if you need to use the restroom, there are two restrooms that's right out in the hall. We have the men's restroom in front of County Court London 3. And on the opposite side of the hall, we have the female restroom in front of the 172nd District Court. All right, now you'll be allowed to use the restrooms. And then when you finish using the restrooms, please come back in the courthouse, in the courtroom. Do not leave the courthouse. If you leave the courthouse, in case it's called, you're not here, then your bond will be forfeited. And what that means is a warrant will be issued for your arrest. You'll be arrested, placed in this county jail, and you bond out. And guess what? We'll have to go through this all over again. And so we're gonna try to get you in and out as soon as possible. And be mindful that you're still in court, so conduct yourself accordingly. I forgot to mention that on the first page, I see she did it, where it says State of Texas versus, there's a line. Print your name, and the reason why I say you print your name is because if your handwriting is like mine, sometimes I can't read it. Okay, so just print your name, and so that we'll know who this form belongs to. Okay? All right, so if you do not have, well, before I stop, does anyone have a question? If you don't have any questions, get ready to go into recess, make sure you conduct yourself accordingly, because we actually, even though we're in recess, we're still in. All right, so at this time, we'll be going to recess.
Before you leave out, can you please complete your paperwork? If not, you're gonna go on and stay.
Good morning, Mr. Paul. How you doing, sir? I'm well, thanks.
Jefferson County Court at Law number 2 is back in session. The court is in session. 2 cases. There are cause numbers 23 CCCR 0154 and cause number 26 CCCR 1186. Both cases are style of state of Texas versus William Kenneth Pulse. Mr. Pulse, is that your full name?
Yes, sir.
Pulse, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Pulse, you may put your hand down. How are you doing, Mr. Pulse?
I'm good. And yourself?
I'm doing fine, thanks for asking. Mr. Pulse, you're representing your case by your attorney, Dustin Galmore. Attorney Galmore is not here, however, standing in for Attorney Galmore is Attorney Haley Simmons. Does Ms. Simmons have your permission to stand in for Attorney Galmore?
Yes, sir.
And Ms. Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. And Ms. Simmons, well, the state is represented in this case by Attorney Cornelius Williams. And Mr. Williams, how are you doing?
Very well, thank you. And how are you and your staff?
We're doing great. Thanks for asking.
You're very welcome.
Absolutely. Okay, Mr. Pauls. I have before me in cause number 26 CCCR 1186, a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, William Kenneth Pauls, on or about October 8th of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of obstructing highway passageway. Mr. Pauls, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Pauls, how do you plead? Guilty, not guilty, or no contest?
No comments.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Pauls, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked no contender, which means no contest. Did you place your initials on this
Yes,
document?
Your Honor.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you have to give, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Pauls, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Pauls, are you a citizen of the United States?
Yes.
State.
Call for State's Exhibit Number
No
1.
objection, Connor.
No objections. The state's exhibit number 1. State's exhibit number 1 will be admitted. And Ms. Simmons, you've advised and counseled Mr. Pauls. Is there any evidence that he is mentally incompetent to stand trial?
None at all, Your Honor.
And Mr. Pauls, attorney Ms. Simmons has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
And your attorney, Attorney Dustin Galmore, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes,
Okay, Mr. Pauls, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. We'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In consideration of Mr. Paul's plea, Your Honor, the state will dismiss criminal number 23 CCCR 0154 for a plethora of reasons, one also of which is that jeopardy has attached and we are in trial on the matter. Additionally, Your Honor, the statute of limitations, of course, would have ran since there would not be a refile within the case. Consideration, the state will offer a $300 fine plus court costs, and will also join with defense counsel in order to remove the required interlock device. Is that correct?
That's correct, Your Honor.
Okay. So, Mr. Pauls, the state is offering that you pay a fine of $300 plus court costs of $330, which comes to a total of $630. Are you able to pay that today?
Yes, Your Honor.
And Mr. Pauls, the state will be dismissing cause number 23 CCCR 0154. And Mr. Pauls, do you understand the state's offer?
Yes,
You think the state's offer in your case is fair and just?
yes, Your Honor.
And do you accept the state's offer?
Yes.
Mr. Pauls, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Pauls, you stand next to the bailiff, follow her directions. Once you finish following her directions, you can go downstairs and make your payment and bring the receipt back up to this courtroom. Also, I think you said he has
As a
interlock as a condition of bond.
Yes, Your Honor.
Could I get that form? Okay.
Mr. Segura is all over it as well as his.
Yeah, so did the dismissal.
Not yet. It's 20.
You ever had bean syrup?
Mm-mm.
It's pure cane syrup.
Yeah.
Bouncing off the. Do we need to be present for the jury?
Man, they done already took off from work. They got our badges and everything. They set to come here. I mean, we just finished this case.
Do I or Dustin need
So
to
they
be,
did, huh?
do me or Dustin need to be present for that?
No, I'll just tell them, what happened.
I'm waiting for them.
Yeah, because we could have did this at 1:30. Well,
Yes, ma'am.
okay, who we have? Mr. Let's see. Malik Ellis,
Yeah.
would you please come forward? Okay, Mr. Ellis, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Ellis, your full name, you may put your hand down. Your full name is Malik Jamal Ellis. How are you doing, Mr. Ellis? I'm doing fine, thanks for asking. Now, Mr. Ellis, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you hired Rife Kimbler to handle your case? Now, before you signed and initialed this document, did you read the document? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Ellis, I read your answers. Your case will be reset. And I see that looking at the docket sheet, you have a felony case. When is that set? I see it's June 1st.
Yes, sir.
Okay, so this case is gonna be reset with the felony. Okay, so your case is gonna be reset with your felony case. Once you get your reset, you'll be free to go. And you have a blessed day. Have a seat in that second chair on the wall and wait for your name to be called by the court coordinator. Okay? Jordan Oswaldo Tupi. I didn't say it. You pronounce it Topi?
Topi.
Topi?
Yes, sir.
Topi, okay. Okay, Douglas County Court at Law number 2 is back in session in 2 cases. Did I have one number on me? Hold on a minute. 6-2. 6-4. 6-6. Okay, both cases are style Jordan Oswaldo Topi.
Yes, sir.
And Mr. Topi, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth shall be God?
Yes, sir.
Mr. Topi, you may put your hand down. How are you doing, Mr. Topi?
Good, what about you?
I'm doing fine, thanks for asking. Now, Mr. Topi, I have document before me that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to hire your own attorney?
Yes, sir.
Okay, now, Mr. Topi, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Topi, I read your answers, and your case will be reset to give you time to hire your own attorney. Just gonna give him a standard reset. Okay, she's gonna reset your case. Once your case is reset, you're free to go, and you have a blessed day.
Yes, sir. Thank you, Your Honor.
Stand, have a seat in that first chair on the wall. Next case is Christine Ann Grayson. And Ms. Grayson, you can put your purse on that table. Ms. Grayson, your full name is Christine Ann Grayson.
Yes, sir.
Ms. Grayson, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Ms. Grayson, you may put your hand down. How are you doing, Ms. Grayson?
I knew.
I'm doing fine. Thanks for asking. Now, Ms. Grayson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And that's the title, Judge's Explanation of Rights to Defendants Without Attorney.
Oh,
Do you recognize this document?
yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to have your case reset to hire your own
Yes,
attorney?
sir.
Now, Ms. Grayson, before you sign this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Grayson?
Yeah.
I read your answers. His case is not being reset right now.
Oh, it's not.
No. They, we calling in somebody.
Okay.
We've holding his on hold. Okay, now, Ms. Grayson,
Okay.
just have a seat in that first chair on the wall. Wait for your name to be called. Once your name is called, you're free to go, and you have a blessed day.
Yes, sir.
All right, thank you. No. You can't step outside. You're gonna sit right there. Okay? Next case is Edgar, what's that, Ahan Flores Perez? Mr. Perez, your full name is Edgar Ahan Flores Perez?
Yes,
Now, Mr. Perez, do you speak English?
little believing.
Okay, a little bit, okay. Just have a seat. See if we're gonna get our Spanish interpreter. Just have a seat in that chair. Have a seat in that chair. We need to get Jennifer. Marcus Maurice Wright. Mr. Wright, your full name is Marcus Maurice White?
Right, WRIGC.
Yeah, right. Mr. Wright, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Wright, you may put your hand down. How are you doing, Mr. Wright? That's good. Mr. Wright, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes,
And are these your initials on the line that states you like to apply for court-appointed attorney?
yes,
We also have another document that's titled Jefferson County Affidavit of Images. Do you recognize this document?
yes,
And on page 2 of this same document, there's a signature above the line that's titled defendant's signature. Is this your signature?
yes.
Now, Mr. Wright, before you signed and initialed these documents, did you read the documents?
Yes,
Did you understand what you read?
yes,
And is everything in these documents true and correct
yes,
to the best of your knowledge?
yes,
Mr. Wright, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is attorney Christy Carlton. Attorney Carlton will be given information to contact you, and you will be given information to contact her. The court coordinator will give you information on how to contact Ms. Carlton, and Ms. Carlton will be given information on how to contact you. Okay? Just have a seat in that first chair on the wall and wait for your name to be called. Did anybody call Jennifer? Just her. Okay. Jenny, that's that. Stephanie Deanne Old. Miss Old, your full name is Stephanie Deanne Old. How you doing, Miss Old? That's good, Miss Old. Would you please raise your right hand? Miss Old, do you swear, affirm, and tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Old, you may put your hand down. How are you doing again? Now, Miss Old, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes,
And are these your initials on the line that state
yes,
you would like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Images. Do you recognize this document?
yes,
On page 2 of this same document, there's a signature on a line that's titled defendant. Is this your signature?
yes.
Now, Ms. Old, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. O, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Giles Cole. Attorney Cole will be given information on how to contact you, and you will be given information on how to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Carlos Guerrero. Mr. Guerrero, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Guerrero, you may put your hand down. How are you doing, Mr. Guerrero?
Good.
That's good. Now, Mr. Guerrero, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that states you like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Guerrero, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Guerrero, I also have before me two dismissals, one on each case. State, is that correct?
That's correct, Your Honor.
And Mr. Guerrero, I'm signing the dismissals on these cases. You'll be able to get a copy of these dismissals from our court coordinator. Once you get a copy of the dismissals, you'll be free to go. And you have a blessed day. Please have a seat in that chair right there on the wall
Thank you.
and wait for your name to be called.
She didn't answer. Glenda went to go to the floor.
Okay. Calbert Dion Ross. Mr. Ross, your full name is Calbert Dion Ross.
Yes, sir.
Ms. Ross, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Ross, you may put your hand down. How are you doing, Mr. Ross?
Good. Good.
I'm doing fine, thanks for asking. Mr. Ross, I have before me two documents. The first document is titled Judge's Explanation of Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of, there's a signature above the line that is titled defendant, is just your signature.
Yes.
Now, Mr. Ross, before you signed and initialed these documents, did your, well, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Ross, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Jennifer DeLage. Attorney DeLage will be given information to contact you, and you will be given information to contact her. The court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat at that table with the chairs in front of it. Right there, yes. And wait for your name to be called. Ariana Gasaway. Okay, Ms. Gasaway. Your full name is Ariana T. Gasaway?
Yes.
Ms. Gasaway, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Gasaway, you may put your hand down. How are you doing, Ms. Gasaway? I'm doing fine, thanks for asking. Ms. Gasaway, I have 2 documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Now, Ms. Gasaway, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Gasaway, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney Mark Fagger. Attorney Fagger will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Cameron Blake Sears. Mr. Sears, your full name is Cameron Blake Sears?
Yes, sir.
Mr. Sears, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God.
Yes, sir.
Mr. Sears, you can put your hand down. How are you doing, Mr. Sears?
Good. How you doing today?
I'm doing fine, thanks for asking. Mr. Sears, I have before me a document that is titled Miss Raji, the gentleman in the green shirt.
No, you're free to go.
Have him Mr. Sears, just have a seat in that chair on the wall. We'll call you back up. Miss. His name is
Yeah, I couldn't pronounce it when he came to my window.
oh, you couldn't? Okay. It's Edgar Ahan Flores Perez. Okay, now I have this here. I have this document. You can show that document to him. He speaks Spanish. Now, Mr. Roger, let me swear you in. Mr. Roger, do you swear or affirm to translate Spanish to English and English to Spanish to help you God?
Yes, Judge.
Okay. Ask him if his name is Edgar Perez.
Yes, your name is Edgar Perez? Yes.
Ask him to raise his right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Vas a decir que voy a llevar en Dios. Sí, y si vas a decir toda la verdad en nombre de Dios. Que todo lo que te pregunte ahí, le vas a decir la verdad.
Sí.
Yes.
See, okay. Tell him he can put his hand down. ¿Cómo está? Bien? Bien, bien. Now, there's a document before Mr. Perez that's styled, judge's explanation of rights to defendants without attorney. Ask Mr. Perez, does he recognize that document?
¿Recuerdas este documento que firmas?
Sí.
Yes.
Now, ask Mr. Perez if there's someone that he brought to court with him.
Sí.
Yes.
And who did he bring to court with him?
¿Y quién es?
¿Cómo?
¿Cómo?
Ángel.
Jorge?
Ángel?
Sí, Ángel.
Angel.
Angel? Angel, would you please come forward?
Yes.
You can stand on the other side. Okay, now, yeah, what's your full name? Okay, and Mr. Angel, you came to court with this gentleman?
I explained the full document to him.
Okay, now you speak Spanish and English?
I do.
Okay, now ask Mr. Perez if Angel explained everything in that document to him in Spanish.
Este señor te explicó todo ese documento en español.
No, ese.
Sí, te explicó todo en ese documento
Sí,
de inglés al español.
sí, me preguntó.
Yes.
Sí.
Okay. And is everything in that now, did you understand what he went over in Spanish?
Y usted entendió lo que te expliqué el señor.
Sí.
Yes.
Let me see that document. Now, okay, here you go. Actually, now you want your case reset to hire your own attorney, is that correct?
Usted quería una cita de corte para que usted tenga tiempo para que un abogado. Yes.
Okay. Okay, so your case is gonna be reset to give you time to hire your own attorney. And
Okay.
okay, once your case is reset, you're free to go and you have a blessed day.
La señora ahí te va a dar nueva cita y cuando nueva cita con todo lo que me abogado, ¿ok?
Okay, and thank you, Angel.
Okay,
You
thank
have a
you,
blessed day
thank
as
you.
well.
Thank
Thank you.
Yeah.
So he speaks some English too. did say a little bit.
Okay.
Yeah, that's.
is Jacorian Danielle Reynolds. Mr. Reynolds, you please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Reynolds, you may put your hand down. How are you doing, Mr. Reynolds? That's good. I'm doing fine. Thanks for asking. And Mr. Reynolds, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendant Without Attorney. And do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state that you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Reynolds, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge?
yes, sir.
Mr. Reynolds, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Now, before she gives you that information, the bailiff is going to give you some bond conditions. And I'm going to go over these bond conditions with you. Okay. Now, Mr. Reynolds, the document that you've just been handed is titled Standard Bond Conditions in County Code at Law Number 2. Do you recognize this? And I'm going to go over this document with you. And this document states that following return of a criminal information in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of a pending offense, and the defendant shall not go near any residence, school, or other location if frequented by the alleged victim. Do you understand that condition?
Yes.
And condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Reynolds, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant issue for your arrest, you'll be arrested and placed in the Jefferson County Jail. Now, Mr. Reynolds, you're gonna have a seat in that first chair on the wall. Wait for your name to be called. Once your name is called, you'll be free to go and you have a blessed day. The Jefferson County Court at Law number 2 is back in session. Court is in session in cause number 24 CCCR 1610. Case is style of State of Texas versus Bellamy I.M. Davis. Bellamy Davis was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court bailiff called the name of Bellamy Davis at the courthouse door. Bellamy Davis did not answer. She has not appeared in court since the court has been in session. The time now is 12:29 p.m. on today's date. Ms. Bailiff, would you please call the name of Bellamy Davis at the courthouse door?
David. Bellamy David. Terrence.
Bellamy Davis' name was just called again at the courthouse door. Bellamy Davis did not answer. Reasonable time has passed to give Ms. Davis an opportunity to appear in court. State, do you have a motion?
Please move for bond forfeiture and warrant entry, Your Honor.
That motion will be granted. Bellamy Davis bond will be forfeited. Warrant shall be issued for her arrest in clause number 24 CCCR 1610. And this will conclude the calling of the court's initial appearance document on today's date, May 5th, 2026. Everyone, please have a blessed day.
I know.